rejection of the proof of loss. How many times has a carrier sent a letter out that says, we reject the proof of loss? Usually, it has to do with the dollar amount. They don't agree with what you guys are claiming as far as what the dollar amount is. And that's not proper grounds for rejecting a proof of loss. So I'm going to go over proper rejection versus improper rejection. Keep in mind, when we go over this, proper rejection may constitute material breach on behalf of the insured. So you really want to make sure that you got everything nice and tight and technical in these deals. So what is proper rejection? Well, typically what we see is what we would call technically insufficient proofs of loss. And what they are you don't have the dollar amount claimed on there, or to be determined on the date of loss, or there's no inventory list for coverage C. It's an incomplete proof of loss. It doesn't have all of the information that the carrier needs to properly investigate. And so if they properly reject the proof of loss, again, it can constitute a material breach. Omit the RCV and ACV information, certainly a reason to do that. You use an inventory or a scope that's vague, not line item out. That's going to be proper grounds for proper rejection. But keep in mind, they can only do so if it's technically deficient. Once it's found to be improper, number one, the courts have said that you have to prove that it was non-compliance, and number two, that there was substantial prejudice. So again, the carrier still has to show that they were prejudiced by the insufficient proof of loss.